Hi, everyone. Good morning. Welcome back. I hope everyone had a nice week so far. If you haven't already, go vote today. Please vote. It's a very important thing. I don't care who you vote for, but go vote. All right. Any questions? Any questions on your mind? We are getting into the thick of the toughest topic of the semester, future interests. And I want to make sure that you understand what we've covered so far. So does anyone have any questions on the life estate, on the fee simple, on remainders, on reversions, on anything?
On anything.
On anything.
Are you feeling good about our answers so far in the meeting?
I'm sorry?
Are you getting good vibes from our
So far, so good.
answers?
So far, so good. You'll get them. Don't worry. Thank you. I said anything, so fair enough. Any other questions? Yes, sir.
Are you gonna like ballpark what you would have given it as far as a grade? You know, like, oh, this is a B, this is a A.
What's your question?
On the midterm, are you gonna ballpark what?
I'll give you exactly what your grade is. Yes, of course. That's what I'm grading.
Some have different.
No, I will grade it the same exact way I would grade the final. That's why it's taking so long. Other questions? Okay, thank you. So I'd like to begin by walking through this chart, which I have on the board. We'll be coming back to this chart many, many, many times over the next few classes, and we will keep adding rows to it. I think I said at the outset, the reason why this topic begins easy enough is because you only have one or two estates to think about. But as we get further along, there are many more different types of estates, and there are many more different kinds of future interests. So the purpose of this chart, and again, you can do this however you want, but I find this to be the most helpful formulation, is to understand the two questions, right? Who owns it, and when do they own it? And these two columns give you that. What is the duration of the estate, and who has a future interest? In other words, who owns it, and when do they own it? The final column, what I labeled words, which is probably not very articulate, forces you to try to memorize the key words that reflect a different kind of estate. You need to become fluent. So if I tell you fee simple, you know that means it's an estate that lasts forever. If I say to A's heirs, you know that means fee simple and it lasts forever. You need to be fluent. If I give you the words or I give you the name of the state, you need to know which is which. And the reason why is on the exam, I won't say, Bill got fee simple. I'll say to Bill and his heirs. And you need to know what that means. All right, any questions on that? All right, so to start, let's start the fee simple. And where did I finish up last time? You're the last one. Okay, thank you. So, did I call on you? Okay, I'll call on you then. So, is that Lauren, right? Thank you. So, Lauren, if I write, and this is simply review, so you get the easiest one to lead off, right? From O to A and his heirs, right? From O to A and his heirs. What is the duration? Okay. Who has it forever? Okay. Well, let's be careful, right? A will only live during A's life, but the duration is indeed forever. Who has a future interest, Lauren? Whose heirs? Very good. Okay. Nothing different, right? The fee simple lasts forever. In the present moment, right, A has a fee simple. In the future, A's heirs have it. No difficulty there. Okay? So let's try this differently. Florencio, tell me, sir, how would you write up a life estate? What words would be used to describe A having a life estate?
To A for life.
Thank you. Exactly right. To A for life. And Florencio, what is the duration of A's present interest?
For his life.
Exactly. So the duration is the life of A. Okay. But now it gets a little trickier. So Carlos, in the situation that Florencio just gave a minute ago, who has future interest? Who has the future interest? And I'm going to modify Florencio's example. His is exactly right, but it's from O to A for life. That's what we're going at. O has a future interest. Very good. Now, what do we call O's future interest, Carlos? What do we call the future interest? Say it. Yes. O has a reversion. And really, it's O and O's heirs has reversion. I'll just say O's heirs to make it easier. Okay. O's heirs has reversion. Now, Carlos, so how do we know? You're right. But how do we know that this is in fact a reversion? What's the rule that tells us that this future interest is called reversion?
He didn't say who he would go to after A had a life, so it goes back to him.
What do we call O? Who's O in this situation? What do we call him?
The grantor.
Bingo. So the rule is, when you have a life estate, and after the life estate it goes back to the grantor, it's called reversion. When you have a life estate and the future interest goes back to the grantor, it's reversion. And the only way for you to know this is to actually read the words from O to A for life. Okay, it doesn't say what happens afterwards. That means it goes back to the grantor. And because it goes back to the grantor, it's a life estate followed by reversion. Everyone get that? Everyone okay with that so far? Okay, very good. All right, Sarah, let's try this one. There's another type of life estate we can write up. So if it's like this, O to A for life, then to B's heirs. Okay. From O to A for life, then to B's heirs. So again, who has the present interest? And how long is that?
Life of A.
Exactly right. So in the second example, it's for the life of A. Exactly right. Who has a future interest, Sarah?
These heirs.
Okay, and what do we call their future interest?
The remainder.
Exactly right. B's heirs has a remainder. Okay. How do we know, Sarah, that this is remainder and not reversion?
Named a third party.
Exactly right. So you know this is reversion because it's the grantor. And you know this is remainder because it's to a third party. You need to remember this. There's no way around it. You will confuse remainder and reversion, I promise. But the grantor having a future interest is called reversion. The third party having future interest is called remainder. Everyone okay with that? Any questions about that? Yes, ma'am.
So right now it's just a difference in words, but is there?
Yeah, there are different rules. Yeah. Stay tuned until next week. The difference between a remainder and reversion has very, very different rules applying to them. But yes, there are different rules. It's not just a matter of wording, it matters. Everyone get that so far? Questions on this? No?
We say
Make sure raise your hand first. Go ahead. Yes.
B has a remainder in fee simple, or is that not necessary?
Yes, you could say that. Yeah, you could say that. I'm trying to keep the chart a little bit cleaner, but yes, that's absolutely right. Any other questions on this?
On the test, will you want us to say a fee simple after the remainder, or will you want us to just stop at remainder?
Well, the more information you give me, the better,
Okay.
right? The more precise you can be, the better. So I feel like, yeah, so B as remainder, I can write it here in fee simple. And O's heirs has reversion in fee simple. I'm trying to keep this chart as not long as possible, but you're exactly right. Reversion fee simple, remainder in fee simple. Questions? No? Okay, we'll move on. So all of the estates that we've covered so far, in one way or another, terminate upon someone's death. Right? Because even if it's a life estate, it terminates upon death. If it's a fee simple, well, if we think about it, when the father dies, it goes to his firstborn son, whatever the rule happens to be. Everything we've done so far involves estates transferring upon death. The next topic is estates that end not upon death. And this can take one of two forms. The first form, which I'll mention only very briefly because we'll cover it in much more detail later, is what's called a leasehold estate. Instead of a freehold estate, it's a leasehold estate. And I suspect everyone in this room at some point has signed a lease. And I'm certain that everyone in this room, when they sign a lease, it goes for maybe 1 year or 2 years or 6 months, whatever it happened to be. A leasehold is an estate fixed for a duration of time. 6 months, a year, whatever it happens to be. And there are different rules that apply to leaseholds. We will cover this much later in the semester, so I only want to mention it now. But when you think of estates that are less than life, a leasehold is probably the most obvious one for you. So any questions on that? Okay. The big one we'll be covering today, though, is not the leasehold. It's what's called a defeasible estate. A defeasible estate. Okay. To understand what a defeasible estate is, you have to understand what it's not. It is not an estate of a fixed duration. It is not an estate that lasts as long as someone's alive. It's an estate that can terminate based on some condition happening, based on some future event. Okay? A defeasible estate is some sort of estate that terminates when something happens in the future. And the reason why these were created was so that people could control land very easily. When I give land to my son, I can give it to him with strings attached, with conditions on it. And if for whatever reason those conditions are not complied with, my son loses the land. This was a medieval manner, well, good choice of words, a medieval manner of restricting the uses of property. You could decide when you give it to someone what the conditions are. Because if you think about it, once you give a piece of land to someone fee simple, you lose control. Once you give them a life estate, you lose control. They can do whatever they want on the land. The defeasible estate was a way for a landowner to control how his land was being used while someone else was on board. Okay. As a practical matter, defeasible estates aren't too relevant today. There's that a little blurb in your book about how the lawyer hadn't seen one since law school, right? They're fairly rare, and they're fairly arcane, and a number of states have moved to eliminate them, but they're on the bar, and you need to know them. So there you go. But we will learn them as best as we can. There are 3 types of defeasible estates, 2 of which we will cover today, 1 of which I will only mention and say nothing more about because they're very complicated. Okay. The one I will mention briefly and not say anything else about them is a fee simple subject to an executory limitation. A fee simple subject to an executory limitation. These are mentioned in your book. I don't want you to even think about them till the next class. Okay? Get them out of your head for today. They will only confuse you. Trust me. The book shouldn't even mention them here. They do, so I will mention it, but no more. The 2 that we will discuss are the fee simple determinable, the fee simple determinable, and the fee simple subject to condition subsequent. Now, those are mouthfuls, right? That is a lot of words, right? Fee simple subject to executory limitation, fee simple determinable, fee simple subject to condition subsequent. I implore you, do not use abbreviations. Someone already did, didn't you? Don't spell it out for now. I know that. I've done this before, right? Don't use abbreviations. I need you to remember these terms in their complete form because they're very similar. They're very similar. And if you start using abbreviations, you won't actually know what they stand for, right? At the end of the semester, maybe you can start using abbreviations, but at least for now when you're learning it, spell it out. Don't say FSSCC, no, FSSCS. I can't even do it, right? Don't do it. It'll confuse you. Or FSD or FSSEL. Just spell them out now. It'll take a couple extra lines in your notes. You'll thank me later. What makes these complicated is terminology. These things sound alike. And remembering the difference between them is an act of sheer memorization. There's not a lot of memorization in this class, but unfortunately this is one of those exercises where you simply will have to memorize it, which is why writing them out is in fact a healthy exercise. Okay? So let's start with the fee simple determinable. The fee simple determinable. Okay. As always, we ask ourselves the two questions. Our two questions are who owns it and when do they own it, right? So the fee simple determinable is the present interest, right? You have a regular fee simple, but then you can modify a fee simple with the word determinable after it. So if you think of the fee simple as a sort of umbrella, you have underneath it these different types of fee simples, right? If you will, this is not a fee simple absolute. It's a fee simple determinable. And what characterizes the fee simple determinable is that it exists so long as a condition is met, right? It exists so long as a condition is met. It's what we maybe call a durational estate. It only exists so long as a certain condition is being met. So, for example, I'll use an example from the book. From O to A, so long as Blackacre is used for school purposes. Easy example. Imagine O really likes the school, and he wants to give some land to the school. So instead of just giving the school fee simple, because he doesn't trust them, they may go, turn around and sell the property. He says, I will give you this land so long as Blackacre is used for school purposes. What tells you that this is a fee simple determinable are these magic words, so long as. These are words of duration. So you have so long as, during, while. Words of this nature that suggest duration, a period of time, will tell you that you're dealing with a fee simple determinable. Okay? And what that means is, so long as this condition is being satisfied, they have fee simple. They can do whatever they want to the land. Okay? However, this is the big however, if the land is no longer being used for school purposes, the fee simple terminates. The fee simple terminates. That's what determinable means. It determines or it ends. That's what the word determine means back in the good old days, right? And Carl, tell me, what happens in this situation if A no longer uses the school as no longer uses the land for school purposes? What happens to Blackacre? Okay, do not say reverts. Okay, you're right, but I want to explain why. Okay, but Carl's exactly right, but just in terms of terminology. Okay, So after, say after it's no longer used for school, right? For school purposes. Blackacre goes back to O. Okay? Oh, you described it right, but I want to use very careful terminology. The future interest, Carl, what do we call the future interest then of O? Yes, sir. Okay. O has a possibility of reverter. Okay. This is his future interest. Now, the reason why I jumped all over Carl, and it's no fault of his own, is we have terms that are very similar. The future interest after a life estate is called a reversion. The future interest after a fee simple determinable is called a possibility of reverter. Think about that. The future interest after a life estate is called reversion. The future interest after a fee simple determinable is called a possibility of reverter. I promise you, you will confuse that in the exam without fail. No matter how many times I repeat this, people will confuse those two. I do not want you to use the word revert casually, and not picking on Carl, because you will confuse yourself, okay? The way you should describe it is you say, O has a possibility of reverter. And don't say POR, don't do it, just write it out, trust me. Say O has possibility of reverter. And that describes what happens after the condition is no longer being satisfied. Everyone with me so far? Yes.
I know you're saying that in order for us to like just keep it clear, to use possibility of reverter, and that's what you would like us to use it, I guess, in the exam. So if we mention it reverts back, that's wrong?
It's not wrong, but it'll confuse you. Okay. I know exactly what you're saying. Law students love using the word revert, but because there's such a close connection between reverter and reversion, you'll, in your head, confuse the two. So it's not wrong, but I'm trying to help you not get confused. That's why I do my best. It won't work, but I'll do my best to try and keep you guys on the right track. I read a study recently that said if you're a good teacher, 80% of your students understand 80% of what you're saying. I mean, you know, we actually had a guy come to the law school last week to give us a workshop on teaching. So he said, if you're a good teacher, 80% of your students understand 80% of what you're saying. So invariably, stuff I'm saying will not get through to you, which is, you know, it's some math, as they say, right? But I will try to make that 80% as big as possible. Yes, sir.
So when O gets back the land on the test, you want us to say it goes back to
Yeah.
the grantor. What about for reversion?
Don't use the verb reverts.
Yeah,
Just don't use it.
Always
Right, go back.
Yeah.
goes back.
Use a synonym. Just don't do revert because it'll confuse you. Because I promise you, one student will say he has a reverter. Instead of saying he has a reversion, he has a reverter. That's not a thing. Trust me, I know exactly what you'll do. The human mind follows very predictable paths for the most part. So the first defeasible state we've studied now, and I want to go back up to our chart and fill this in. Okay, is the fee simple determinable? And we'll use this example from O to A, so long as Blackacre is used for school purposes. Okay, so we say that the duration, right? The duration of A's estate is so long as a Blackacre is used as a school, right? As long as it's being used as a school, A has it. And indeed, if A dies, A's heirs have it, as long as it's maintained as a school, and it goes on and on. In theory, at least, right? In theory, at least, the fee simple determinable goes on forever. If this land is always being used as a school forever and ever and ever and ever, well, then it's effectively fee simple, right? There's never any termination of condition. However, always lurking in the background, right? Always hiding in the background is O, right? O and his heirs have a possibility of reverter in fee simple. O and his heirs have a possibility of reverter in fee simple. They're always waiting in the wings, right? Watching. It's like, wait a minute. They took down the school and they put up a storage closet, right? Or they put up a warehouse, whatever it was. Because they can always say, we got it. Everyone with me so far? Now, what makes the fee simple determinable such a, should I say, violent future estate is that it terminates the fee simple determinable automatically. It terminates automatically. The second, the instant that that school is demolished and turned into a factory or whatever it is, it goes back to O. The instant that school is torn down, it goes back to O. It's automatic, right? The estate terminates automatically. There's no need for O to go to court. There's no need for O to file a lawsuit. There's no need for O to challenge whatever in court. It's automatic. This is why these estates are very much frowned upon in the modern era, because a slight error can result in the immediate termination of an estate. And you notice this in the reading, but in several points they say we prefer the other one, the fee simple subject to condition subsequent, because there has to be steps taken before the property transfer is over. But the fee simple determinable, followed by the possibility of reverter, is automatic. Yes, ma'am.
Who enforces that? It doesn't have to go to court. Has the title company just switch over the deed or?
So what ends up happening, right, is after the condition is satisfied, if the people on the building contest it, right? So say, for example, I'll give you an easy example. They tear down the school and they say, oh, shucks, right? You're right. We weren't supposed to tear down a building. It's yours. Here are the keys, right? In that case, there will be no judicial remedy. But for the most part, and I'll ask you this question, if someone knows they have this condition on their land, would they tear down the school?
Yeah, they just do something else.
Okay. So what ends up happening in many cases is they're not even aware the condition's there. And that was the case in the playground case we have in the reading. So then you actually have to go to court and say, hey, I got this condition. It's a 100-year-old written deed on a napkin, right? But it's still valid. And then a judge say, well, you know what? That's no longer a school. Judgment for the plaintiff. Or they say, well, it's a warehouse for school equipment. It's still a school. But the key point is it happens automatically. And you'll see the difference in the Marin Holtz case within a couple minutes of why it matters. So everyone get the fee simple determinable followed by the possibility of reverter. And one way you can remember this, and again, I told you no abbreviations, but this may help. If you just remember the mnemonic device, FSD-POR, right? The fee simple determinable always follows possibly reverter. These are a pair. You need to know these reflexively. You need to remember these. You will confuse these, I promise you, but you need to try your best to remember these. Okay, any questions on the possibility reverter or fee simple determinable? No? Okay. The next defeasible state I'd like to discuss is the mouthful one, right? The fee simple subject to condition subsequent. All right, Jose?
From my understanding.
No, I didn't ask a question yet. I appreciate your enthusiasm. Let me ask the question first. Do you remember from contracts the concept of condition precedent and condition subsequent? Does that ring a bell? Did you not learn that? Some saying yes, some saying no. That's not the right answer. Because everything you learn in 1L, you have to know in 2.5 years. Anyone remember fee simple? I'll come back to you, Jose. Anyone remember condition subsequent versus condition precedent? That ring a bell for anyone who took the final and didn't wipe it out? Well, good. So tell me about it.
Subsequent after.
Okay. Well, yes, subsequent means after. Thank you. Subsequent means after, and precedent means before. So what a fee simple subject to a condition subsequent means is you have it until some condition happens, right? You have it until some condition happens, but when the condition happens, you don't have it anymore, okay? And the way you can distinguish the fee simple determinable from the fee simple subject to condition subsequent is by the language, okay? They're often very similar. In fact, you'll see in the cases, sometimes the courts can't even tell them apart. But if you're a good lawyer, you will write them clearly enough. So for example, from O to A, okay, so this Blackacre, from O to A, but if Blackacre not used for school purposes, okay, the grantor has a right to re-enter and retake. I'll give you an easy enough example. Blackacre from O to A, but if Blackacre is not used for school purposes, the grantor, that is O, has a right to re-enter and take it. Okay, I wrote that in a very complicated fashion deliberately, and I'll explain why in a minute. But here, the key language is this but if. But if is what we call conditional language, right? If you remember from logic, in high school, like if P then Q, right? You remember this? P's and Q's, the modus tollens and modus ponens, all these good logic games. You know, for the L side, good. You remember you didn't wipe that one out, right? You remember that test. So these are conditional languages, right? They suggest when a condition happens, then something else happens. And there are different ways of writing this. So for example, there's but if, there's provided, there's however, there's on the condition that. Okay, I realize that sentence doesn't read well anymore, but you get the idea. If you see these sorts of words, you know that it's a fee simple subject to a condition subsequent. A fee simple subject to condition subsequent. Okay. Now, the future interest, again, you have to memorize this. Future interest is what's called a right of entry. And you will sometimes see re-entry, but I prefer right of entry. You see them different ways, but I prefer right of entry. This is two less words you have to remember. A right of entry. When the present estate is a fee simple subject to a condition subsequent, the future interest is a right of entry. You need to remember that. Yes, sir.
It's a right of entry for O, right?
Yes, it's the right. It's the right of entry for the grantor. Okay. Yes. So thank you, Hunter. The future interest is a right of entry for O and his heirs in fee simple. Okay. When you have the present interest is a fee simple subject to a condition subsequent, you know that based on these conditional words, then you know that the future interest is a fee simple. I'm sorry, the future interest is a right of entry. A right of entry. In this case, a right of entry in O and his heirs in fee simple. Now, the framing of this is actually important and it helps you, right? I'll come back to you, Jose. Jose, what does right of entry suggest? What does it mean to have a right of entry?
That you give the land back.
But what do you have to do to get it back? It's right in the phrase. It's called a right of entry. What do you have to do
You
to
have
get?
to claim your right.
You have to enter, right? You have the right to enter. You don't need to do it. You can imagine a situation where A no longer uses it for school purposes, and then O doesn't really care anymore. Maybe this is O's great-great-grandson. He doesn't care anymore, whatever, right? And he decides never to enter the land. In that case, A keeps it. A keeps it. The biggest difference between the fee simple determinable and the fee simple subject to condition subsequent is the transfer of ownership. With a fee simple determinable, it's automatic. It's automatic. The second the condition's violated, it jumps back to the grantor. However, for the fee simple subject to condition subsequent, the grantor with a future interest must exercise his right of entry. He must exercise it. He must take legal steps to reclaim it. This involves filing a lawsuit, but he must take legal steps. The failure to take those legal steps means it still resides in A. Right? This isn't a situation where the second the school is torn down, ownership shifts. The grantor must exercise his right of entry and take affirmative legal action to reclaim the property. Okay? It's not automatic. O must take what are called legal steps to exercise right of entry. Was your hand up before? I think I saw. Yes. Yeah, 1 and 2. Go for it.
My question is, like, so they don't meet the condition, but O decides that they're not going to enter the land. It owes heirs into the land.
There's actually a statute of limitations that runs. There's actually a statute of limitations that runs that when O becomes aware of the condition being breached, it'll vary by state, 5, 10 years, whatever it is. But you have to bring it within a certain amount of time. Now, if O is not aware, the statute doesn't start running. But there's a clock, right? Because there's always an incentive in property, if there's a dispute over title, to bring that to court as soon as possible and not let it linger as people die and get old and memories fade and documents disappear. But yes, there's indeed a statute of limitations that runs. Yes, sir.
So they actually have to go to a judge. They can't just show up, say, look at this deed, you failed, give me the keys.
Basically, that's what happens, yeah. They have to go to a judge, show them the deed, show them the condition, but to demonstrate that, in fact, the condition was breached, and then the court will say, okay, unless you can prove to me that the condition is still being satisfied, transfer ownership now. And it's not even enough that they can go build a second school, right? That wouldn't do it. Because the condition was breached at that moment in time, that exercises the right of entry. That gives them the chance to challenge it. You can't remedy that. You can't cure it later. Yes, Jessica?
The duration applies only to fee simple subject to condition subsequent, or does it apply also to fee simple determinable? That's that limitation, the duration of
Well, if you think about it, with a fee simple determinable, it happens instantly. There's no need to take any legal action, right? The second, with a fee simple determinable, let's go back up to our example here. The instant, right? The instant when the school is demolished, it belongs to O. Okay? You may need a judicial declaration for that, but it's not the same deal. Now, your question, which I think is what you're getting at, is what happens if, there's a fee simple determinable and, O waits 20 years before he does anything, right? In other words, he knows that A is still on the land. He knows there's no school. That's what's called squatting. It's called adverse possession, which you'll study in property 2. So again, if you don't act on your rights quickly enough, you can actually lose it. You'll study this next semester. So even with a fee simple determinable, if you do nothing, he's on your land, he's violating the rules, and you take it, you can actually lose it through adverse possession, which is often called squatting rights. But you'll do that next semester. Yeah, I usually get that question at this point, which is good. Right on track. Everyone okay with me so far? Let's fill in the chart, Jeremy. So here we have from O to A, but if whatever, then O has right of entry. Okay. So Jeremy, what is the duration of A's estate? How we describe it?
I would say A has it as long as it
Yeah. Yeah, exactly. A has it. I'll say until better, but until a condition is violated. I'll phrase it like that. But that's what you said is exactly right. A has it until some condition is violated. Okay, and then Cody, finish up. What do we call the future interest?
O and his heirs retain a right of entry in fee simple.
Perfect. O and his heirs have a right of entry in fee simple. Exactly right. This chart we will keep coming back to. I'd like for you to commit it to memory. You should be able to fill in any of those boxes, cold. I don't have to think about it. This will help you immeasurably, especially once you start getting to the other types of estates, which are far more complicated. Yes, Sarah?
In the duration column, should we add the proviso that as long as O asserts their right?
Yes, right. So I was going to get to that in a minute, but you're exactly
Okay.
right. So it does not terminate automatically. Okay. O must take legal steps, right? He must go to a court and say, hey, judge, that school was demolished. Give it to me. You must take affirmative legal action in order to exercise your right to enter the property. At common law, the entire idea of a right of entry was literally that. You would enter onto the land, and that was enough. But we have courts today, so you can't just barge onto the property. But the phrase right of entry is almost a historical relic, like much of what we study, that in the old days, you'd be like, all right, I'm here, get lost, right? You'd literally enter onto the property. But that sort of self-help is no longer permitted. Okay. Any questions on this? Okay. Now I'm going to mention again briefly the fee simple subject to the executory limitation. I'm not going to put on the chart quite yet, but I want to draw your attention to one fact. In both of the examples we used, the future interest goes back to the grantor. The future interest goes back to O. But what if the future interest goes to a third party? Okay. If you have a defeasible estate and the future interest goes to a third party, then we have the fee simple subject to an executory limitation. The rules on that are complicated, and we'll do that next week, but I want to at least flag that for you, or next class, whenever it is. When the future interest after a defeasible estate goes to a third party, it's a fee simple subject to an executory limitation. I was very careful with the examples today to always make the future interest go to O. I was very careful in that. That was deliberate, because these are actually easier rules. So you always need to pay attention at every juncture who has the present interest and who has the future interest. If it's going to a third party, there's an entirely different set of rules that apply than if it goes back to the grantor O. Questions on the fee simple determinable, the fee simple subject to the condition subsequent, or either the future interest therein? No? Okay, I'll move on. before we get to the first case, the Marin Holtz case, one point which was mentioned somewhat in passing, but I'll dwell on for a second. At common law, you could not transfer future interests. Okay, at common law, you cannot transfer the possibility of reverter or the fee simple subject to a condition subsequent. You cannot transfer those inter vivos during life. The only way that those future interests can move was by inheritance, right? When dad dies, his future interest goes to his son or whoever it happens to go to his heirs. You cannot transfer it inter vivos. The modern trend is that they can be transferred, and from what I've researched, it's actually somewhat unclear. But in Texas, the possibility of reverter can be conveyed inter vivos. It's a little fuzzy, but I'm pretty sure if I say that, that's right. The reason why it's fuzzy is that these don't happen very often. People today simply don't use defeasible estates. So you only encounter these if they're fairly old documents that are still floating about, that you have these interests from 100 years ago. But I'm pretty good footing saying that in Texas they could be transferred inter vivos. But if you actually wanted to do something like this today, you would use a trust or you'd use a covenant or some other mechanism to control the land. Okay. All right. So, any questions before we move on to the first case, Marin Holtz? Okay. So, let's see. Jessica, did I call you last class? I don't remember. Okay, Jessica, what does it mean to quiet title? It's mentioned in the case, and you'll see this over and over and over again this semester. What does it mean to quiet title?
To eliminate any questions or contingencies that may
Exactly.
exist about the title.
Exactly. So quiet title is not like, shh. You're not telling someone to be quiet. What quiet title means is you go to a court and you say, listen, there are questions over who owns what, right? There's doubt, there's uncertainty. And we want the court to make a declaration about who owns what. What are the different interests in a piece of property? So I'm sure you'll see this on the exam, A files a suit to quiet title. That simply means A goes to the court and says, hey, judge, listen, we can't work this out ourselves. We want you to declare who actually owns Blackacre, who has a future interest, who has whatever. Everyone get that? Okay. So this is actually somewhat of a tricky case. The facts are somewhat complicated, so I want to walk through this more closely than I usually would. So in 1941, okay, in 1941, the Huttons executed a deed for 1.5 acres to the trustees of the school district. And the deed says, and I'll read this quote, the deed says, this land to be used for school purposes only, semicolon, otherwise to revert to grantors herein. This land to be used for school purposes only, semicolon, otherwise to revert to grantors herein. We'll get in a few minutes the actual act of what that means, but I want to first walk you through the chronology because the chronology is a little bit tricky. Okay? So, Bianca, tell me please, what kind of estate, okay, what kind of estate is that deed transferring? And I'm not asking specifically, but generally, what kind of estate are we talking about here? What's the umbrella category? Well, is it a fee simple absolute? Is absolute? It's not absolute. So what do we call a fee simple that's not absolute? What was the new term we introduced today? At the very beginning of class, the term, or even the title of today's class. Exactly right. This is a defeasible estate. And Bianca, tell us, how do we know this is defeasible?
Because the estate can terminate
Before?
before
Yes, exactly. It's defeasible because the estate will end prior to the death of whoever. Okay. We'll get in a couple minutes of whether this is a fee simple determinable or a fee simple subject to a condition subsequent. Right. We'll get there in a few minutes, but everyone agrees that this is some sort of defeasible estate. So, Lily, tell me please, what did we just say about the future interests after a defeasible estate? Can you transfer during life the future interests following a defeasible estate?
Oh, no.
Thank you. Right. Under the common law, you could not transfer, right? You could not transfer a future interest following a defeasible estate. So Lily, just one more question. It says here, and this is why I jumped on Carl before, otherwise to revert to grantors herein, who gets the future interest in this initial deed? I mean, which party gets it? It says it. The grantor, right? This is not a third party getting it. This is going back to the grantor or the grantor's heirs. There's nothing wrong with that deed, right? You are perfectly able to keep the future interest in your family. There's no problem there. Okay. The problem occurs a couple months later in July of 1941, where the Huttons purported to convey to Jack Main the 1.5 acres and the reversionary interest. Let me say that again. The Huttons purported to give Jack Main this reversionary interest. Okay, this future interest. So, Crystal, was that transaction valid? Could the Huttons transfer during life, inter vivos, this future interest?
No.
They could not. So what happens then to that future interest? Where does it remain, Crystal?
It remained with the school.
The future interest.
So the future interest remained with the grantor.
Exactly. So the first thing you have to understand is even though in July of 41, Hutton thought he was giving this reversionary interest to Jack Main, he wasn't. And the way property law works is the court effectively strikes that clause out. It's as if there was never reversionary interest granted because it can't. So it actually remains, right? It remains with the family, the grantors. All right. So subsequent to that, Hutton dies intestate, meaning he dies without a will. Okay. Jack Main then tries to convey the reversionary interest to Marin Holtz. Jaime, was that transaction valid? Could Jack Main transfer the future interest to the Marin Holtzes? Why not? He never had it. Exactly right. All this while, the reversionary interest remained with the family, with the grantor's family, right? It could not be transferred to this new party. Okay? And then Jenny Hutton dies, so we're left over with Harry Hutton, who's the son, and Harry Hutton has the reversionary interest. Okay, he has the future interest, whatever it happens to be. So then things get a little bit, crazy, right? So in 1973, the school district no longer holds classes there. They use the building for storage or something, whatever, right? So then in 1977, Harry Hutton conveys to Mahrenholz all of his interests in the school land. Okay. So, Sean, let me ask you this question. Again, can Harry Hutton convey a future interest to Mahrenholz?
Yes.
What we just say? Can you convey a future interest in life?
No.
So he cannot convey a future interest. What is the only thing that he could have conveyed to the Mahrenholzes? It's not what happened. What could he have conveyed in theory, at least? You can't transfer a future interest. So what kind of interest can you transfer? Okay. So the only thing, right? The only thing that Hutton could have transferred to the Mahrenholzes was a present interest. Still, you cannot transfer a future interest. So the question becomes, right, and this is the $1 million question for this case, is in 1977. Okay. In 1977, what interest did Hutton have? Did he have a fee simple, which he could transfer, or did he have some sort of future interest which he could not transfer? Okay, this is the $1,000,000 question. This is why this case is somewhat complicated. Because subsequent to the deed to the Marin Holtz, Hutton disclaimed his interest in favor of the school board, right? Whatever that means. And don't worry about the recording stuff. We'll do recording later. That doesn't really impact this case at all. Students always get confused by the recording. Just pretend it's not there. The rules on recording are actually somewhat complicated. We'll do it later. So this goes to court, right? And the question then becomes, what interest did Hutton have in 1977? Did he have a fee simple, which he could have conveyed? Or did he still have a future interest, which he could not convey? And this case turns on how we understand the initial grant. Okay? How we understand the initial grant. And I'll read it to you one more time. It says, this land to be used for school purposes only. Otherwise, to revert to grantors herein. So, Lindsay, tell me please, let's pretend for a moment that this was a fee simple determinable, right? Again, the words are not clear. Let's just pretend it's a fee simple determinable. If it was a fee simple determinable, what would Hutton's future interest have been called?
Assuming
Yeah,
that
assuming.
it was not used, the storage was not school purposes.
It doesn't matter. What is the future interest that follows a fee simple determinable?
It's a possibility.
Exactly right. The moment, right? The moment that school was no longer used for school purposes, what happened to that future interest?
It automatically becomes feasible.
Automatically. So had this in fact been a fee simple determinable, instantly, right? Poof. The moment that the school stopped using it for school purposes, they made it a storage warehouse, whatever. Harry Hutton now had a fee simple. And Lindsay, just finishing up, if Hutton had a fee simple, could he then sell that to the Marin Holtzes?
Yes.
Then the sale would have been transferred. The sale would have been valid. Had it been a fee simple determinable, he would have gotten it instantly. And he could have then transferred his fee simple to the Marin Holtzes. And there's no question, right? This later business about disclaiming it for the school would have been irrelevant because he'd already given away his interest to the Marin Holtzes. Everyone get that, right? Everyone get that one. So Jacqueline, let me ask you the other question, right? Let's say, just assume for a moment that the court said that this was actually a fee simple subject to a condition subsequent. Fee simple subject to a condition subsequent. What would Hutton's future interest have been called in that case?
The right of entry.
Yes, ma'am. The right of entry, exactly right. Had, and I'll Jacqueline finish up with this, had in fact this been a fee simple subject to a condition subsequent, followed by a right of entry, what would have had to happen after the school stopped being used for school purposes? What would have had to happen first?
Or he would have to go to enter.
Yes. He would have to exercise his right of entry. Okay? He would have to exercise his right of entry. Jacqueline, did that ever happen in this case? No. He had never exercised his right of entry. So up to Landon, we'll jump over here. Because he had never exercised his right of entry, was the transfer to Marin Holtz valid? Was there anything he actually could have transferred? Why?
Because he didn't have fee simple.
What was it still at that point?
Future.
It was still a future interest, exactly right. Until you exercise the right of entry, it is still a future interest which cannot be transferred during life inter vivos. Then he could have renounced his interest to the school, right? Because there's still a future interest. You can always give up your future interest. You're not selling it. You're simply giving it away, and you're basically relinquishing it. You can always relinquish a property interest. So had it been a fee simple subject to condition subsequent, he could have given his interest to the school. He could have given it to the school, and in that case, the school would have it. Everyone get that, right? So this case turns on how you interpret the language. If it's a fee simple determinable, then the transfer to the Marin Holtz was valid. It was a fee simple subject to condition subsequent, the transfer was not valid. Because it was still a future interest which could not be transferred into post. Everyone get that much? Yes, yes, Sarah, but when you get to afterwards.
I just want to make sure I understand the terminology just right. So
Yes.
to transfer means to sell. Is that synonymous to sell?
Yes.
And then to gift something.
It's not really a gift. So technically speaking, if you think in terms of the bundle of sticks, where are my sticks? Right? Yeah. In terms of the bundle of sticks, right? If the son has the future interest and the school has the present interest, right? If they combine their interests together, it becomes fee simple. So it's not actually selling it. He's basically relinquishing his future interest, in which case the school then has fee simple.
So he couldn't gift it to anyone else other than.
Yeah, it's actually a very particular thing. You can always relinquish your future interest to complete the bundle of sticks. Yes, Crystal.
So if it was determined to be fee simple determinable, and that first sale was valid, and your sticks are together, present and future, and like what actually does the Malum? What actually do they have? Like, do they have the same deal where okay, you have this land, but you can only use it for school? They get that whole thing, or is it just they can do whatever they want?
No, once the sticks are united, they get fee simple. They can do whatever they want. So once the son relinquishes his condition, right, they can then build a skyscraper. Right? They can do whatever they want. I think that answer your question. Okay, good. Yes, sir. Feasible subject to condition subsequent. Don't start abbreviating. You'll drive yourself nuts. Yeah. Just say, I know it's a mouthful. Fee simple subject to condition subsequent. Go ahead.
So if the condition is met, but then they I'm trying to think of how to best say this, but basically
they don't enforce the right. They don't go after them.
Well, so right. So the school, for example, let's say use it as storage for 6 months and then go back to using it as a school.
Ah, well, what's interesting. Okay, so in this case, ultimately the judge decided that storing desks was a school purpose, right? That sounds silly, but let's just assume that's right. The second you stop the condition, that gives you the right to enter immediately. And you can't cure that by building another school, right? In this case, the judge ruled, and we can argue about it, the judge ruled that scoring desks and that was a school purpose. That doesn't seem consistent with the intent of the grantor, right? I don't think he gave land to use as a warehouse. I think he gave land to use as a school. But court seems to be somewhat flexible here. Okay. Yes, Jaime.
Just a variation of that question, but let's say there's a school on the property, and for whatever reason they had to knock it down, and there's going to be a period of time where it wasn't going to be used for that purpose.
Mhm.
They plan to rebuild it again. Could they either say, well, we're still planning to use it for that purpose, or could they get special permission?
And you ask a fair question, right? A lot of this boils down to the judicial construction, right? If they tell the court, look, the school's dilapidated, like it's in bad conditions, we need to tear it down for a semester, build it up again next summer, right? I think a judge would be very hard pressed to find the condition being broken. To use an example in the reading, there's one example is actually a Texas case where someone deeded a piece of land to a church to be used for church purposes, right? And they struck oil, and they found oil underneath the church property. So they were pumping oil underneath, and they were praying on top. I'm sure that a very heavy collection plate after that, right? Is that a violation of the condition? The court said no. I mean, they're still churching, right? They're still doing religious services. So the condition is not breached. What I'm trying to get at here, and you'll see this in this case, the next one, is that judges are very hesitant to find breaches of condition because it results in a violent transfer of property, right? People have been there for decades. They built, expectations, a church, school, whatever. So judges don't like to upset the apple cart. Okay. So ultimately, and I really don't want to dwell too much on this part, which is actually the holding, but the court held that it's a fee simple subject condition subsequent. Why they held it, they thought the language was more conditional than durational. I think it could go either way. I mean, I frankly, I'm not crazy about the reasoning here, but ultimately the court held this was a fee simple subject condition subsequent because it was conditional language. As a result, the future interest was a right of entry, and because Hutton had not exercised his right of entry, therefore the transfer to the Marin Holtz was void, and it went on. I'm much less concerned about how you interpret the grant than that you understand the consequences of choosing one path or the other. That's much more important from my perspective. Because I'm not convinced the court got it right, but the consequences of having a fee simple determinable or a fee simple subject to subsequent, those are much more important. Yes, sir. Yeah.
Did the grantor get in trouble because he used the word revert instead of order?
Yeah. So I think that's why I jumped on Carl about this before. The fact that he used the word revert probably pushed it over the top. In all other respects, it looked durational, right? In all other respects, it looked like a fee simple determinable. But the fact that the word revert was there made it seem like a possible reverter, right? Even though, in all other respects, it was conditional. So when you combine a little bit of the durational language and a little bit of the conditional language, it makes for a very complicated scenario, which is why they put it in your book. But had they not used the word revert, I think it would have, it could have gone the other way, but I don't know. Yes.
On the exam, since you want us to focus on the consequences of either way, do you still want us to maybe, especially if it's hard to tell if it's words of duration or words?
I'll answer your question this way. If you go look at my old exams and you see how I frame the deeds, you'll know what I'm looking for.
Okay, that'll be more clear than this case.
If you go and you look at the way I framed it, yeah, I mean, but I can trick you on a lot of things. This is something I don't want to trick you on, right? It doesn't tell me much about your knowledge of property if you can say, well, these are more durational words, these are more conditional words, but that's not a particularly salient measure of your knowledge of property law. In fact, that was in our class discussion, the hardest part was everything else. So I hope I answered your question. Yes.
I just thought I read that they created a fee simple determinable.
Oh, did I invert in my head? You're right, I did. So I'm sorry, you're right. Thank you. You know why? Because I thought it was a fee simple subject condition subsequent. You're right. The court, I read my notes wrong. Sorry. I make mistakes. I'm sorry. Yeah, the court said it creates a fee simple determinable with a possibly reverter. Okay. I think that's wrong. I think the reason why they went that way is because the word revert was there. But I think if you look at the words, it's almost certainly a fee simple subject condition subsequent, which is why I think I said that.
Okay, that makes more sense.
I'm sorry.
No, thank you.
Sometimes I read my notes wrong and I try to think about it on the fly and then I get sidetracked. So my apologies. May never happen again. No, it'll probably happen again. It happens from time to time. But I appreciate you're catching me. But again, that outcome almost certainly is wrong, and you'll probably see why if you look at it closely enough. But anyway. Okay. Other questions on the first case? Yes, Carl?
Okay. So you believe that it's a fee simple subject condition because the word only is synonymous with provided?
I think that's right. I think it's a conditional word. I think this was Christian's question a minute ago. The fact that the word revert was in there made them think of the possibly reverter, which is closer to the fee simple determinable. I think that's why they did what they did. But again, that's why I jumped on you 20 minutes ago saying don't say revert, because that may mix things up. But yeah, I occasionally
courts get stuff wrong, and I think this is probably one where they got it wrong. But you know, who am I to say? Okay. All right, let's move on to the next case. Okay, the next case is the Odd Fellows, which is, has anyone ever heard of this group before? It's like a fraternal lodge. I think I have a picture of one of their. Yeah, here it is. The Odd Fellows building in California. This is, you know, like a fraternal organization where I think it was only men at the time, but men were able to get together and help with charity and do different forms of civic service. And this case presents a situation where land is constrained, okay? The condition imposed on the land is one of constraint. So you had a guy who was a member of this organization, and he donated effectively this piece of land to this group. And the condition said, this property is restricted for the use and benefit of the lodge, second party, only. And in the event the same fails to be used by the lodge, or in the event of a sale of any or part of the lot, the property is to revert to me, to the grantor or my grantor's heirs. I paraphrase it somewhat to make it easier. So effectively, this grant says the property can only be used to the benefit of the lodge, and if the lodge ever sells it, it comes back to me or my heirs. Everyone understand what's going on here, right? What do you think his intent was, Graham, when he wrote this deed? What do you think his intent was? What do you think he was trying to accomplish by writing out this deed?
He wanted to create a feasible subject to a condition.
Okay, but describe in general words, what was he trying to accomplish by framing this the way he was?
I guess to use the property the way that he wanted it to be used, and then when it didn't happen.
Do you think he wanted this land to be kept by the organization if they did something not for the lodge? Do you think he wanted this land to be kept if they sold it to someone else? No. Right. It seems pretty clear from the intent that he did not want this property to be used for any purposes other than this organization's activities. And this should actually ring a bell and remind you of the case with Jesse Lead. Remember when you said, I give this to whatever her name was, Evelyn, to live in, do not sell the house. Remember she underlined twice, do not sell the house. So there's this concept, right, of what's called a restraint on alienation. If you give someone a piece of property and you say that you can't sell it, right, the land can never be sold, that's bad, right? It's effectively a fee tail. You're keeping it in a person's bloodline indefinitely. It can only go to their heirs. And those are, generally speaking, not enforced by courts anymore. But that isn't what we have here, and this is the point the court tries to stress. Okay, Cameron? Is that Cameron? Cameron, tell me, is this land going to be stuck with the Odd Fellows forever? Will it be stuck with them forever as if it were a fee tail? I'm sorry, louder?
No.
Why not? What happens if they decide to stop using it for lodge activities? Don't say revert. Don't say revert. Just say go back. See? Trust me on this one. Please. You'll confuse yourself. Yeah. In the event that they stop using it for organizational purposes, it goes back to the grantor. And then, Cameron, what happens if they try to sell it? What happens if the lodge tries to sell it? What happens then? Goes back. So on the one hand, right, this looks to be an awful deal for the lodge, right? They have to keep using it for these purposes, and if they stop using it for these purposes, it goes back to the grantor. And I suspect that the district court and also the dissent are saying, this is insane, right? How can we, in the year, whatever, 1970, whatever this year case was, right? How can we have such a condition on land, right? But Natalie, defend the other position, right? Why is this not necessarily such a bad thing for the lodge, right? Why are they maybe complaining way too much? Right? Why is this something the court should enforce, that you can actually enforce this condition where they lose it the second they stop using it for this purpose?
But I'm making the argument as to why the court.
Defend the majority, yeah. Why is it okay that they can only keep this land so long as it's being used for purposes of the organization? Why is that not a bad thing? Defend it.
Well, I mean, I guess it's not such a bad thing that it only be used and enjoyed.
How did they get it in the first place, Natalie? How did they get this land in the first place? From whom? A gift from whom? Who was the grantor? Yeah. Why did he give it to this organization in the first place?
For the purpose of the lodging.
Without reasoning, why did he give it to them? You know, he was dying, right? Why did he decide to give this to this organization? Charity. Yeah. This was an act of charity, right? The lodge got a free piece of land. That's kind of nice, right? In California, land's expensive. They didn't have to pay for it. They got this land for free. But that gift, there's no such thing as a free lunch, right? That gift came with a string attached to it. And the string attached to it was, if they decide to ever stop using it for their organization's purposes, or they wanted to sell it, well, too bad, guys, you just lost your free land. Maybe you should have thought of that when you accepted in the first place. Now, the dissent, right, makes the argument. The dissent says, look, this is a restraint and alienation, right? We should not be enforced. What happens if the building was being used for 100 years for this organization's purposes, and then the organization goes out of business, right? The civic organization shut down. Do we really want to go find 20 or 30 heirs of the grantor and chop up this piece of land? So the dissent says, look, we're legal realists. We should give effect to language based on reality. And he would simply say this was a grant of fee simple, and the dissent would have struck out the condition altogether. But I think you see in this case, the majority was saying, we are going to enforce the contract as written, right? It's harsh, but that was the terms on which the property was transferred. And the dissent is saying, why are we being so harsh? This is not something the court should enforce. It's almost against public policy, if you will. The dissent would have simply struck out the condition and transferred it fee simple and had been done with it. Everyone get that case. Again, this one, I'm not too concerned about the construction of the language, but the key point is that the majority was willing to enforce this harsh language, whereas the dissent said this is a restraint and alienation, we will not support it. Yes, Elizabeth, please.
Like they spend so much time talking about this restraint on alienation, but it just seems like they wouldn't have that anyway. How would they be able to sell that?
Right. So what's interesting here is that a restraint and alienation, that part won't be enforced, right? The provision of the deed saying it can't be sold. So effectively, the organization's put in a tough spot. They can either keep using it for a lodge or they'd be forced to sell it. But if they themselves use it for something else, then they lose it. That make sense?
Would it be any different if that language was never in it?
Which language?
The it cannot be sold.
If the it cannot be sold language is not there, then they could sell it very easily and get rid of it. But the issue here is the courts won't enforce the language saying it can't be sold. The issue in this case is whether it can be used only for lodge purposes. That is a valid purpose. Make sense? And actually, you're next, so you're right on target. I want to turn in the remaining few minutes to page 272. There are a number of review questions. We'll do a couple of them in class, but I encourage you after class, the answer key is there. Don't cheat, but try and do these questions yourself. So Elizabeth, just read question number 1, please, on page 272. You can read it yourself, but no, read loud. Yeah. Okay, Elizabeth, so tell me, what is A's interest here? How would we describe A's interest? Exactly. And the way you know this is by reading left to right. I know we all read left to right, but pay very close attention to commas. To commas. To A and her heirs, right? If you would just stop there, you say, oh, that's fee simple. We have a comma. Comma, but if. But if is a word of condition. This is a word that tells us we are dealing with a fee simple subject to condition subsequent. If you think about it, it actually makes sense, right? You have fee simple with a comma, and the stuff after it puts the condition subsequent to it. That actually tells you what you have. Always read left to right to comma. This will become more trickier later. But the A and her heirs, but if black acre is used for any purposes other than ag, then O has right to re-enter and retake the possession of land. Okay? And Kenneth, what is the future interest following a fee simple subject to condition subsequent called? The future interest following the fee simple subject to condition subsequent. What does what's O's future interest here? Go back to your chart if you don't know. You need to memorize these. The future interest following a fee simple subject to condition subsequent. No. The future interest following a fee simple subject condition subsequent. What's it called? It's in the answer. It's there. The word is in there. If you read it, read it. Read the question number 1 again, please, Kenneth. What is O's future interest? It's right there. What do we call it? What do we call it? You're supposed to be in your notes. You didn't write the chart down. That was a mistake. Kristen, what do we call it? A right of entry or right of reentry. I'm not up here for idle worship, idle banter. You should be copying what I'm putting here. It's for your own good. The future interest is called a right of entry. Exactly right. The future interest following a fee simple subject condition subsequent is called a right of entry. Okay, very good. Cece, you want to read number 2, please? Okay, Cece, so let me ask you, what is the consequence of A building houses on this land that's limited to agricultural purposes? Yes, ma'am. It violates the condition, right? But what happens after the violation of the condition? What must happen before the property is transferred? Yes, there's a right of entry. Does a right of entry operate automatically, Cece? What has to happen in order for the right of entry to be exercised? Exactly, right? Legal steps must be taken. B must actually go ahead and go to court and seek a judgment in order to exercise his right of entry. Okay? However, and this is actually a tricky part of the question. Okay? O devised her entire estate to B. Because it was through inheritance, the future interest could be transferred. Had it been done during life, it could not. So in this case, B has a future interest. and B would have to take legal steps to re-enter. Yes, sir.
I have a question about these conditions as far as like purpose. For the exam, is it going to be very clear that the purpose is like not being met or not being used? It's like the agriculture one. I see what would be the problem of like building like 2 houses for like yourself to use the land.
Yeah, I mean, that question probably isn't drafted as well as it could be, but I think several residents means they mean like a gated community or something. I think that's what they're getting
I
at.
just want to make sure it's going to be very clear.
It'll be clear enough. It'll be clearer than this. All right, Kemi, do you want to read number 3, please?
Conveys black acres and anywhere there so long as black acres are used for residential purposes only.
Thank you, ma'am. So, how would we describe A's interest there? Exactly. How do we know it's a fee simple determinable? Exactly. And here we read left to right. Notice there's no comma there, right? There's no comma. The comma gives you a hint there might be a condition, although that won't always hold. So the A or error, so long as this is conditional language. And then, can we finish it up? What do we call the future interest in this case?
Possibility of
Exactly. And who has it? O has a possibility of reverter. Yep. You have to memorize this, guys. Fee simple determinable, followed by a possibility of reverter. Okay, exactly right. And our last remaining minutes, Jimmy, read number 4, please. Oh, I'm sorry, Christian. Thank you, sir. Yes.
Taking the facts of problem 3, suppose that some years after the conveyance, A begins construction of a factory on Black Acre. O has died and devised for entire estate to be. What is the state of title in Black Acre at conflict?
Okay, so what happens, Christian, the instant a factory is constructed on Black Acre with this estate?
He has a possibility of murder.
Does any action have to be taken, any legal steps have to be taken? Bingo, automatic. So the second a factory is constructed, B now owns Black Acre and fee simple, right? The fee simple determinable in A goes away, and B now owns it, fee simple, period. If you didn't get any of these examples, again, the answers are actually in the back of the book, so I encourage you after class to go back and review these. Don't worry about 5, 6, 7, 8. They're a little bit more complicated than they're worth. But at least the first 4, I think, give you a pretty good sense of what to expect. Make sure you understand this chart. Again, we'll come back to this many times, and we'll keep adding rows to it. So it may behoove you to simply keep a separate document somewhere in your notes or in your notebook, and we just keep adding rows to it. Questions? You're already zipping up. Have a good day. I'll see you all on Thursday.